right. Okay, hello. Still getting used to my new tripod thing. I don't even know what to call it. So the tripod thingy it is. Alas. Oh my gosh. All right, here we go. Still need to get this one set up. So just a minute. Oh, and I gotta put my hair up. All right, come on, internet. Be my buddy here. Do you mind? Like, we don't care. We don't care what your problem is. We do what we want. So I'm fighting with my internet for a moment. But that should go in a second here. Let's see. How'd that go? Oh, no. Sorry. No, thank you. And then over here. Oh, my goodness, everyone. Oh, my goodness gracious. Oh, I'm on the struggle bus. All right, just a minute. Here we go. Is it gonna work? Are we gonna have to find alternative things? I'll have to find. The things will have to be the alternatives. All right, almost. I think we're almost there. We'll see. Come on, internet, you can do it. Sorry, everybody, I'm just sitting here talking to my stuff here. All right, let's get going. Let's get the show going. Are we good? No, we're not good. We're not good yet. Oh, man, come on. All right, well, everything on this one works, but... Oh, wait, no, that's the wrong one. No, wait, that's the right one. Oh, my goodness, I have it. Oh, all right, everybody. That was a journey that we just all went through together. Good evening, everyone. Good evening. Hello. Hope everybody is having an okay day today. What day is it? Is it Wednesday? We can hope, right? Fingers crossed. Thanks, Jim. I appreciate that. Well, if you've all been with me, I don't know this stuff, where the stuff goes. Hello, Madame. Hello, Gumdrop. Oh my gosh, best name ever. That's definitely one of my most favorite candies, along with jelly beans. Shh, don't tell anybody, okay? Hi, Lulu. Welcome in, everyone. It's been a few days. It's been a bit of a struggle for me, so I've not been able to come in and do my own lives, but I've been hanging out with the other cool people. So if you go over to Army Barbie or Miss Manda Rose, those ladies, I usually try to come and hang out for a little bit. So if I can't do a full live myself, I go and complain to them. So did you just get lucky? I don't know. Maybe. Uh-oh. I don't know. Hey, yo. Hey, yo, what's up? Sing with the cool people in me. That's right, Joe Boo. Also, you can see Joe Boo's name in the comments. And of course, anytime he's doing a live and he does all kinds of fun, trivia stuff, etc., he's always a blast. So you might see me over there too. And of course, if Legal Dad, yeah, he's a cool kid for sure. Legal Dad comes up too sometimes. So we're all kind of part of, Law Talk, I guess. Law, and we're not here to sugarcoat it. Kind of talk. So, hello, is it G to G? Is that all right? I mean, I don't know. That's not a bad word I'm saying, right? I hope not. Hi, Sven. Welcome in. So, tonight might be a little bit shorter. Well, I don't know. I say that and then it's long, and then I'm like, well, never mind. So, good. Thank you. So I have a couple things I want to do. First, we have this incredible 81 page case that just came out today. Oh, real quick, I have to show you this. I can't make a big deal out of it because the talk then thinks I'm like sponsored, but I'm not. But look at this cool ring. It like spins. I'm even talking quietly so they don't catch me. It spins. It's like a worry ring. Isn't that the coolest thing ever? Oh, I just love it, love it, love it. So I wanted to bring it on, and I'm like, if I'm wearing it, maybe they'll know that it's not sponsored. Yes, fidget, exactly. Although really, really fun and pretty. All right. So I'm going to move this over here. Now, I don't want to attempt the people from coming and getting me here. So, yeah, I was afraid it would get caught. Oh, yes, and it does, Tishy. It does get caught. So it's like you got to put that on after everything's on, and you have to not touch it ever again or have anything else touch it. But if you're okay with that, then it's fine. Then it's fine. All right. So I know I am like just all over the place tonight, everyone. All right. This decision out of Massachusetts was decided today. So this is the DVD case and versus Homeland Security. Now, so we've got a couple of things. Oh, I can't help it. Tishy. The DVD case, everyone, is about whether or not when the people without the paperwork get put into detention and then shipped out, whether or not the out includes either your home country or you stay in the U.S., or they were shipping and still are shipping people to a third country. So this is what we call the third country situation. Now this has been going on since the beginning. I think one of the very first cases that was filed was the JGG case. For those of you that may remember that crazy town time, and that of course was in DC, and they decided if you want to do a habeas case, which is what they had to do, really the U.S. Supreme Court said, dude, do a habeas case. So then they did. And so then they all went down to Texas. So with the DVD case, hi, Kaya. Hi, welcome in. Hi, June Marie. Oh, thank you so much, Bruce Wayne's mother. I tell you what, it's the sparkle, right? I thought the sparkle would be really fun under the light. Ooh, okay, squirrels. Anyway, back to it. So this was a group of people that were like, dude, we would rather go to our home country than to a third country. But if your home country is going to orchard you or various other awful things, then they need to talk about that. So, oh my gosh, I've missed you too. I really have missed you all so much. But the decision came out today then on whether or not this was okay, because what we had, and this is a really good moment to remember, that the plaintiff can ask for a summary judgment, right? So we know what that is. That's the first 6 counts in the Angeron case against Mr. Orange, right? So the first 6 counts had been done through a summary judgment. The judge was like, okay, all of these. But we had number 7 count, the one that we were all working on in there. So summary judgment means the judge has enough information, just with the record, no trial needed, and the plaintiffs are the ones to ask for that here. Now, the defendants, of course, the government here, asked for a motion to dismiss, and that's very, very typical here. When you see filing for a motion for summary judgment, many times that motion to dismiss will go together. Now, we didn't used to have so many cases exploding all over the place for the government, so this is unusual. So things like a motion for summary judgment, motion to dismiss would take some time. They would go through and read it and be like, okay, I think we got it. But there's no time anymore. So this judge wrote 81 pages, and it's fantastic, although I have not annotated it yet. So I do want to wait to annotate here, but I did want to just remind everybody because it's such a huge case. So I was going to read the first couple of pages, if that's all right with everybody here, and then we're diving into contempt. we've got some contempt of court issues going on, really, big time. It's not great. It's not great for them. It's not great for them. The us and them. So we have the DVD case, where the question is third country. Third country. What's the right like for deportation? Here we go. Deportation. And this came out. This is an order from the court. And just came out today. So 2/25. All right. So there we go. Again, we've just got a couple. Oh, thank you so much. Just a couple pages to give you an idea of where we're at. I do want to really do a full live with this once I get it all read and such. But sometimes I don't. A case this important, I really need to take a little bit of time with. Right. Oh, thank you so much. Thank you. This speech last night sucked. I was thinking for a few minutes, I'm like, what if I pop some popcorn and we could do like, old school when we used to sit back in the old days, everyone, when we used to sit in front of the TV and throw popcorn at people. Those were the good times. But then I thought that's a high price to pay though. So I know, right? Oh my gosh, the good days. We'll find those days again, but that was hilarious. That was so fun. All right, I have hot cocoa here. I'm worried it's too hot. Let's see. Not too hot, and thank the gods. All right. Right. That's enough. Well, fair enough. All right, so I have three different sets of docs that I want to get through tonight. So let me get started. So again, that was a quick overview here of the DVD case. Let me read. Oh yeah, Lucky. See, no, Lucky. Hi, Willie B. Hello. All right, here we go. First page. I'm just reading 2 pages out of this. Memorandum and order on defendant's motion to dismiss, right? So the government was like, you need to dismiss. There's no reason why you should even be listening to this case. That's what they do in all of their cases. And on plaintiff's motion for a partial summary judgment. That just means a part of the case, which is why I was bringing up the Anger on New York case with the Mr. Orange, right? So I think there were 7 counts, civil counts. 6 of those were decided under motion for summary judgment. That's what we would refer to as a partial summary judgment. So the first 6 are done. The 7th goes to trial when we're talking about the huge fraud case for Mr. Orange in New York. All right, so here we go. This case is about whether the government may, without notice, deport a person to the wrong country or a country where he's likely to be persecuted or tortured, thereby depriving that person of the opportunity to seek protections to which he would be undisputedly entitled. The Department of Homeland Security has adopted a policy whereby it may take people and drop them off in parts unknown in so-called third countries. You don't ever want a judge to write a decision with so-called in it when they're referring to you. That's not a good sign. In parts unknown in so-called third countries, and quote, as long as the department doesn't already know that there's someone standing there waiting to pew them, that's fine. We have a footnote here. The judge was not impressed, by the way. Not impressed. Yeah. So here's our quote here if you're wanting. He's citing to the docket, which everyone has the ability to see on Court Listener. Then it will tell you where he's at. He's actually looking through the transcript of a hearing. So, and then response was from defense counsel. And he's using defense counsel's literal words, exact words here, in order to make his point. I think that's very wise. Very, very wise. Here we go. Hi, Kristen. You can find it by tapping? Oh, I don't know. Oh, no, Kristen. Is there something in here I'm supposed to do? Oh, I don't know how to do any of this stuff. all right. Well, I'll take a look after I finish reading this, because then I'll be ready for the technology, perhaps. All right, here we go. Back in it. Sorry, everyone. So footnote number 1 down here. Yeah, you'll have to walk me through it like I'm a 2-year-old, really. But we'll do it here. I got serious stuff. That's right. So, quoting defendants. Next, it is not fine, nor is it legal. And that means the judge is pissed. Oh, thank you, Kristen. I appreciate you so much. I really do. Congress made it, quote, the policy of the United States not to expel, extradite, or otherwise effect the involuntary return of any person to a country where that, quote, person would be in danger of being subjected to torture. Now, we would call this, in the rest of the areas, we call this the CAT. It's not a treaty, I don't think. Oh, maybe it is a treaty. But there is an agreement worldwide here when it comes to how to deport people. And a big thing is that it's not okay to just send them to a place where you know they're going to be orchard to unalive. That's just not cool. So they don't want to do that. Congress decided, oh, thank you so much. Oh, look at the hat and the mustache. I love it. Congress decided that the government may not remove someone to a country where her life or freedom would be threatened on account of, here, let me pull it down a little bit, her race, religion, nationality, membership in a particular social group, or political opinion. Footnote 3 down here is citing the code, which, if you're wondering what we're talking about, this is the code down here. So it's 8 U.S. Code Section 1231 sub B sub 3 sub A. So you want to pull that law, it's down at the bottom there. So back up, these are our laws, and it is with profound gratitude for the unbelievable luck of being born in the United States of America that this court affirms these and our nation's bedrock principle that no person in this country may be deprived of life, liberty, or property without due process of law. Citing the Fifth Amendment here. So that's a little bit of a ding, right, on the birthright citizenship case, which is still on the horizon. So I think we love that when the judges do that. Just a little ding there. It may surprise the reader to learn that in its most candid moments, the government agrees. As recently as March 24th of 2025, during the pendency of this very litigation, the Department of Justice told the Supreme Court, quote, we would have to give the person notice of the third country and give them an opportunity to raise a reasonable fear of torture or persecution in that third country. Now, that's the thing. When you start saying stuff to SCOTUS, that's going to get used again. And so that's exactly what's happening. The judge is like, look, you already said this. I'm not making it up. These are your words here. And so, if you're interested in the oral argument, it's the Riley v. Bondi case down here. Ooh, this is not looking good for the government right now. Hello. Hi. Welcome in. Let me bump this up a little bit. I want to make sure can everyone see the comments okay? Just let me know if I need to push it up a little higher here. All right, so this was not a remarkable admission, but rather a well-established, decades-old application of due process principles. Is this good, Crimson? Or should we move it up a little bit more, or is this okay? Dun, 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 dun. Let's see. I'm waiting. Be patient. Is this good? Are we good? Okay, yes, we got it. I think we got another yes. Whatever you like. Oh, now you sound like a lawyer. All right. So this was not remarkable. Let's start back a little bit here. Oh, I'm happy to help as much. Thank you so much, Kaya. Thank you, Willie B. I'm happy to help. I can't be on as much as I would like, but I'm thankful to be here tonight. So here we go. Let's start back up here again. This was not a remarkable admission, but rather a well-established, decades-old application of due process principles. In 1998, the Seventh Circuit held that it was a fundamental failure of due process not to give sufficient notice of a country of removal. And we've got our citations here, the Kossoff case. A year later, the Ninth Circuit followed suit and held that the last-minute designation of a country of removal violated a basic tenet of constitutional due process, citing Andreation. The thing here that I think is really important, everyone, to keep in mind as what's going to happen is we're going to see a heck of a lot of appeals. And something to keep in mind is that the court, because this judge is really smart, the courts pulled cases from the 90s. So there can't be this question of like, oh, well, they're picking on us. They're just trying to say that we can't do stuff, misinterpreting. No, the judge actually pulled two cases that had nothing to do with this Supreme Court or, well, maybe Thomas, because he's really old. But other than that, it's like, look, we didn't make the rules. The rules are here in our federal courts. So I think that's very smart. These were not even then controversial decisions. On this point, the NIS has advised us that it's now in agreement, and the government thereafter memorialized in official policy its recognition that the individuals in those cases were not afforded the opportunity to apply for protection as appropriate. And then we have footnote 5 here. Which is the execution of removal orders for countries to which aliens may be removed. And this is in the Federal Register. And they're citing this specific case. Well, both of them, the Kossoff and the other one. So both of those. So that's good. That's good. We've already got then some strength behind that any appellate court could use. All right, so here's our last little bit of kind of our syllabus, our intro here. And then I will switch our topics over. So according to its new policy, actually, I think I missed that whole piece. I was so excited. I was so excited. Hi, Chaos. Good to see you. All right, here we go. But less than a week after the above quoted comments to the Supreme Court, the Department of Homeland Security changed its position. Now, according to its new policy issued March 30th of 2025, immigration officers need not give notice or any opportunity to object before removing someone to an unfamiliar and potentially dangerous country, as long as the government has generally received assurances that no persecution or torture will happen there, right? So are you really going to tell me in El Salvador that they're going to be like, no, we're great, we don't harm anybody? No, that's not right. So that's not a good look for the government. This new policy, which policy means that the executive branch is involved here, everyone, just FYI, which purports to stand in for the protections Congress has mandated, fails to satisfy due process for a raft of reasons, not least of which is that nobody really knows anything about these purported assurances. So they're trying to change the law like in a really sneaky way by putting out either executive orders or executive memos telling people to do stuff. That's how they're trying to get around the law. And the judges are like, I'm sorry, we're here and we see what you're doing, and no, that's not how it works. Whom do they cover? What do they cover? Why has the government deemed them credible? How can anyone even know for certain that they exist? These are basic questions that the Constitution permits a person to ask before the government takes away their last and only lifeline. For these reasons and those stated below, the court will grant in part and deny in part defendant's motion to dismiss. dismiss other claims and grant the remainder of plaintiff's motion for summary judgment. This means the whole case is being taken care of, either being dismissed or summary judgment is decided. So there's no pieces left, even though it kind of sounds like it because we've only got partials here. So the court will stay its judgment for up to 15 days, allowing defendants to move for a stay in the First Circuit. Right? So they're going to appeal, and what the courts are doing now, and I'm seeing this more and more, is they're staying the lower cases. I mean, we got so many cases on stay right now, especially in immigration. I've never seen this many cases. This is why you go through the full process before you start dinking around with your appeals, but whatever. So the First Circuit will be the next place to go, but they will pause this case until the First Circuit makes their determinations. So that's happened a lot here. All right, everyone. So that's a quick overview of what's going on in the DVD case, which of course is our most recent decision coming out of federal court. Where are we here? We're in District of Massachusetts here. So that's good. Right. That's what. Right. Yeah, I mean, there's a lot going on. Convince the admins trying to overwhelm and break the system. Well, they can certainly try, but, thank you so much. They can certainly try, but I think what you're seeing and what you'll continue to see is, I don't know, I think it's one of the fundamental pieces of being an attorney. Truly, to be an attorney is that absolute and complete respect for the Constitution. Now, we don't have to. Oh, no. Oh, my gosh. No, did she just go down? Oh, hold on, everybody. Amanda, emergency. What just happened? Is she all right? Oh, my gosh. How? Man, I just can't even believe that. There, keys. Right. Sorry, Manda break. Is she down? Oh my gosh, no. Oh, I know. Randomly ended. No. Oh my gosh, that sucks. That sucks so bad. Oh man. Live and then it just, if it discontinues, it means it got taken down. Oh no. Oh, Amanda. Or Amanda. That sucks. Oh, man. Yeah, that's a bummer. All right. So I got to get back on target here, but that's just a heartbreaker right there. Heartbreaker. Maybe she can get Barrister to go on, and then she can be like, what's up? You try that. Hello, Nani. Good to see you. Yeah, they're really upset about that. So, okay, where was I, everybody? Where was I? I can't even remember. There was a good point that I was chasing after, but now I have forgotten it over and over. I know it's hard. I don't know why she keeps coming back so many times, because she loves it and she wants to help us. Yeah, someone's got to be doing that. What are attorneys allowed to do during a trial? Can they use underhanded tactics? So no. Well, you're not supposed to. Look, I never saw this because I was worried, but is it called You Better Call Saul? Maybe that was his, whatever. So that sleazy lawyer stuff, that actually does happen. All right. And I don't want to give up too much information because everyone's like, what? So, but there's a bit of truth to that. And so if you get kind of like a slimy, gross attorney that's like, we don't care what you do, we just want to win, those kinds of things, then yeah, you're going to have some bad dudes. But the majority of us, significant majority of us, we have taken an oath to the Constitution. And, it's our duty to keep that oath and to not dismiss it. And so a lot of us take it very seriously. In fact, most of the attorneys that I've talked to, which are very much like me, we just, the Constitution is our best friend. Now they wouldn't say that. They'd say, stop it. The Constitution is very important. If you want to violate the Constitution, then, you're a crappy attorney. I guess is how I'd put it. In my opinion. Right. Pam Bondi, no thank you. Oh, and the a meal guy too with the bald head. Oh, I don't like him. It's not because he's bald either. He's just like, good Lord. Right. Well, best friend didn't talk back. All right, diving in again, everyone. Here we go. All right, so here's the next thing. Oh my gosh, this has been on my desk for a couple of days, and I'm like, I've got to do it. So this is the case here, and it's Baljinder Kumar versus Louis, I don't know if it's Louis Soto. All right, and what this case has to do with isn't really as important as the fact that the government violated multiple times the court order, right? So we've got a court order set out in this case. And of course, it's involving, some kind of immigration issue because of course. But what happened was the court was so upset. They said, you need to tell us, you government need to tell us how many times you violated my court order, what it was, what you did, and when you did it. And that's amazing. We don't have these stats. We don't have these kinds of numbers. If they're true or not, I'm leaning towards they're true in any of our other cases. So yet, I wanted to really take some time and look at this because I think this could be applied to pretty much all of their cases. So we'll be going through a chart here. Oh, yeah. It's very, very much eye-opening. We'll be going through their chart and then making sure we remember what kind of issues for contempt we'll be able to get through. So here we go. We'll do a couple of opening paragraphs and then dive on in to VC. Every time Clarence comes up, VC, I have a jump scare. All right. Now this is the Kumar case. Oh my goodness gracious. The world's gone crazy. Except for this one little spot here at my table. We're not crazy. Oh my gosh. All right. So this is the declaration here. And I love too how people are leaving ICE and going and talking to other people. That's one thing that the orange fella doesn't have the ability to do. Like you can't force people to do non-disclosure if it's not allowed, right? So this non-disclosure forms that have helped him so much in the past, they're pretty weak when he's in the office of the president because everything is taken down. There's nothing that's private. It might say private, but then 10 people can still read it. All right. Government court order violations is what we'll put here. Order violations. Here we go. There we are. And, we're not too far behind. We're a little bit behind. Not too far. I know. Right, resident. FBI whistleblower in Congress. Oh, yes, VC. Oh, my gosh. I'm waiting for the transcript. I have, Jack's transcript I was reading through, and I'm like, okay, let's get this next section. So I'll go through a couple of paragraphs, and then we'll hit the graphs here and try to figure out. This is their own words. This is the government's own words here. So I, Jordan Fox, pursuant to 28 U.S. Code Section 1746, declare as follows. So if you're declaring it and it's false, that's perjury under the law. Next. Oh yeah, I need a shinies tonight. Number 1, I am Chief of Staff to the U.S. Deputy Attorney General, an Associate Deputy Attorney General, and a Special Attorney for the United States Attorney's Office for the District of New Jersey. Now, we already know there's some hinky stuff going on in Jersey, right? But up here at the top, we've got Todd Blanche, right? And then here is Jordan as a Chief of Staff down here. Okay, so he's the one that wrote it. Number 2, I submit this declaration in response to the court's February 5th, 2026 order. So he's like, dude, I got to do it or you're going to be in trouble. Requiring the U.S. Attorney's Office to conduct a sufficient investigation and enumerate each instance in which the respondents or people acting on their behalf violated an order issued by a judge of this district between December 5th and the present. So this judge isn't playing around here. They're not playing around. I mean, they've had enough. And I can say this is really, a lot of our judges are starting to very clearly set things out now in their orders. Yeah, right. There we go. Right. All right, here's my sticky notes back again. Number 3, given the importance of the district-wide issues identified by the court, I greatly appreciate, again, this is him talking, I greatly appreciate the court granting me leave to sign this declaration on behalf of the office. Yikes. Oh, do we need another emoji? Yeah, we might. I do not have firsthand personal knowledge of all the facts. So this means what we're hearing, what we're listening to is going to be hearsay. But hearsay can be admissible actually into court. I'm not going to go through the 27 exceptions here, but especially when it comes to work product or documents that are public. But that's what he's saying here. Like, look, I don't have personal knowledge, but here's what I've got. But I've got personally undertaken and supervised an investigation as required by the court. Because they're always trying to kind of jerk this whole situation around where they're like, yeah, I looked for it. Sure we did. Well, we don't have to because of the president. President told us we don't have to. We don't have to do what you tell us. You know, it gets really tangled up in here because of that. Yeah, so 27. Yeah, I know. 27 grievances, right? So just real quick again, because I'm just like the squirrels are everywhere. So if you go into the federal rules of evidence, I'm just going to take a moment here. Hearsay's a really tough concept to figure out and to figure out how it works. So federal rules of evidence, and hearsay itself is defined under Rule 801. So let's see, 801. Here it is. So Article 8, hearsay. So definitions that apply to this article, exclusions from hearsay. So this sets out the beginning, right? So this is the beginning. What's hearsay? What's not hearsay? And then what about opposing party statements? So if there is a confession can be used using this piece of that. But then, and I'm just going to go real quick here, but then what you'll notice, the rule against hearsay, very small, it just says you can't use hearsay unless there's a rule or an exception. And then we start 803, where they start literally going through all of the exceptions. Over here, we got 7 through, and so it just, all of the exceptions, because there had to be a change each time someone brought something to court, and the court's like, yeah, that's all right, let's add another one. So there you go. Hearsay in a nutshell for you. All right. I was like, that's not even a good nutshell. But here we go. To ensure that the court has all requested information, my declaration is organized in the following manner. This declaration describes first our understanding of what constitutes a violation of a court order. That's okay. I think that's okay. You can say that. Second, this, although I think the court will probably be like, that's not the same, but you can still do that. Second, the search methodology and parameters to identify violations of any of the approximately 547 immigration habeas matters. See that? They're already citing it. They're like, dude, what they are saying in this whole piece, and again, I'll keep going through it here, but what they're saying is they are so understaffed, they cannot keep up with the sheer quantity of cases specific to this administration, specific to habeas corpus. So that's the problem. And they keep citing it. They're like, you got 547 cases, and a lot of those are going to be class action cases where it's a group, because this is how many times you're jacking around with the law. All right, so dang, Yeah, just for their office is what I'm thinking when it comes to the habeas cases, because I think habeas gets filed a lot in DC. Although, honestly, I'm not sure. I mean, I would think that way, but I'd be open to being wrong on that. No, it's not a good excuse. Yeah, sure would. Great name. But the courts are getting pissed off about it. So there were a couple of things that really pissed off the court. Number one, J6ers that were all let go, right? And then kind of this inability to file a proper document and such. That also is. And then now we're getting in here. They're saying we need more time and etc. And the court's like, dude, we gave you time. It's not our fault that your policy has made it so you can't handle this level. It's like your policy's issue, not mine. Hello, hello, hello. So Rose, welcome in. All right, here we go. Right, so 547 immigration habeas matters filed during the relevant period. And third, each violation that has occurred during the relevant period defined as December 5th to February 12th. Yeah, this is bad. If you've got attorneys using the I've got too many cases argument, like the fact the judge even lets you make that argument before kicking you out of the courtroom, like that's a miracle. Like we're all overworked, man. You're not special. Types of court violations by respondents. This now, all right, is where they're going to set out all of the ways they violated the court's order. So let me get some hot cocoa for that. Hello. Christy Nichols. Oh my gosh. Nicholas. Oh my goodness. What a fun name. Christy Nichols. Ooh, extra K's. We love that. Yes. All right. Here we go. Types of court violations by respondents. So by the government. This is all of them writing it. So number 6, in the interest of transparency and to ensure full compliance with the February 5th order, our office takes a broad interpretation of what constitutes a violation of a court order to include the following. So of course it's going to be pretty broad. A, missed answer deadlines. Anytime respondents have answered or responded to a petition after the deadline set by the order to answer. So this is major here, and I've been complaining about this for a while. That when you're suing for, even if it's just suing to make the government stop, you file a petition, right? Usually, what you see usually. Let me make sure. Oh, you can't see my handwriting over here. Chicken scratches. Okay. So there you go. So we file a petition. Petition is filed first saying, stop the stuff. And then an answer comes in, right? And then we do some kind of a negotiating or agreement, try to work on that, as we also work through discovery where we're pulling in more information to see what's happening. And then we get into pretrial. And then trial, again, this is just a quick overview, trial here, and then post-trial motions, all right? So the problem here on all of these stinking cases, everyone, is that the petition gets filed, and then there is a request for a temporary restraining order, which is like, 2 to 3 days typically, and then a preliminary injunction, which could be 2 to 3 weeks. Excuse me. Very rare, actually, until this situation occurred. So rather than going and getting a petition and then having the answer, we're having to, wade through all of this crapola here, trying to keep harm away from the people who've been harmed. So we have all this stuff. We even have preliminary injunctions going up to the U.S. Supreme Court. But this is the order of things, right? So we're all the way up here with these cases because we can't go down here until the TROs and PIs are sorted out. Many of the cases, the petitioners have said, we don't want a preliminary injunction or a restraining order because it's going to take too long to go up to SCOTUS and then come back down. too much harm will be done. So they've withdrawn their requests for those because of that. And, that strategy is certainly working here. So they're saying a missed answer deadline. Literally, the answer is the kind of document that they're talking about. We call it an answer. Next, missed bond hearing deadlines. Anytime respondents have not successfully facilitated the U.S. Department of Justice executive branch, for immigration, holding a bond hearing for a petitioner within the time set by the court. This is huge. They are missing the habeas corpus cases, right? So we've got people in detention that are saying, dude, this isn't right. And so then they will get an order saying, release them, release the person. And they are saying here, well, we're missing the bond hearing deadline. So I'm not really sure if they can really get out or not. Or some people are kept like up to 2 weeks has been my understanding, where they've had an order to release that person and they've not released them. And it's because, according to them, because their workload's too heavy. But you got somebody sitting in detention days after they've been granted, freedom during this period of time, going through that bond process. And they're like, we're not going to because we're too busy, running around with our riot gear or something. I don't know what they do in their spare time. All right, this bothers me. I don't know if you've noticed. Number C. So we have post-injunction transfer. Now, again, going down that line that I was explaining. So after the injunction has occurred, anytime the U.S. Immigration Customs Enforcement and ARO, we'll just call them the cubes and the ERO, all right, transferred a petitioner from one detention facility to another after the court issued an order enjoining the petitioner's transfer. So what they're saying is, anytime we've missed this deadline, which has been multiple times, whoops, sorry about that. Next, post-injunction removals. We've got transfer. Are they going down to Texas? Are they going to Louisiana? We don't really know because they are not keeping track of this stuff very well because they're not trained properly. And that is not an opinion. That's just facts. Now, next, after the injunction, so removal after that. Anytime the cubes or ARO removed a petitioner from the United States after the court issued an order enjoining a petitioner's removal. So, all right. They're saying, whoops, we picked up the people, we shipped them, and sorry about that, is what they're talking about here. Right, disappearing people absolutely, you are correct. So we have transfers that are not being done properly. We have removals not being done properly. Oh, I know. Yeah, there's rules, people. And then late release from custody. So these are technical pieces, the transfer, the removal. Now we're talking about custody. Anytime the cubes and the ARO released a petitioner from custody after a deadline set by the court order to release such a petitioner from custody. And so we'll go through how many times did they do this? This is all in the chart coming up. All right, so this is how many times did they do that? I've even heard, and I can't remember where I've heard this, so take it with a grain of salt, but I've heard that sometimes they'll release people with no paperwork, no identification, nothing, like in the middle of nowhere, basically. And so they have to figure out their own way back to whatever state it was that they lived in. And that's a problem. The really bad guy that was dismissed with prejudice. Oh, I've not. Oh, Dolphin, no. Let me write it down and then say no again. And I'm not surprised, everyone. So what we're talking about here is that we had a pretty bad defendant, and in federal court, if you miss your deadlines for filing, you don't, play around, pussyfoot around, I guess, like these, whatever people. It's serious. Like, bad dude, you miss your deadlines, you're done. You can lose your license for missing a deadline. You can be kicked out, although U.S. attorneys right now, whatever. And I'll have to research this, but I'm so glad you brought it to my attention. This is a really, really bad dude, and he's out now because of their incompetence. So you missing a deadline is also another way of saying that the attorney is incompetent. Am I going to spell that incompetence? Oh my goodness. I'm sorry, everyone. I'm like, I'm a lawyer, but I can't spell incompetent. So help me out with that. That's huge. I'm going to have to look into that. That's really huge. And I'm not surprised. I knew it was going to be starting pretty soon. We're going to start seeing more of those kinds of cases, honestly, everyone. And if it's dismissed with prejudice, can't come back. Yeah, can't come back and try it again. Even if it's homicide. Right. Yeah, oh man. All right. Here we go. Oh my gosh, I'm bummed out. Oh, thank you so much. Yeah, I tell you, these particular ones had a lot of sparkle, and I was like, we need that tonight. Post-release ATD. Anytime the Cube Eero has imposed conditions of supervised release or other alternatives to detention, that's what the ATD is, on a petitioner released from custody pursuant to a court order prohibiting post-release conditions of supervision. So, oh my gosh. All right. We had different tracking, like the ankle bracelets or even, keeping them under house arrest, something like that. Here, they've been laid, it looks like, on a petitioner released from custody pursuant to a court order that's prohibiting that. So they're still leaving the ankle monitors on. They're not taking them off. So that when the court orders you to take off the monitor, you got to take that off. And if you don't, you got problems. So that's what they're talking about here. Incomplete evidentiary production. This is huge. Oh my gosh. If you were a normal attorney, you weren't dealing with this kind of crap, you'd go back and forth and be like, that's all I have. And, you go back and forth. But here, what's going to happen is if they're not giving all of that information, they're going to start getting into huge problems where prosecutors are prosecuted themselves for not giving all of the information out properly. I mean, that's a violation right there. Oh, incredibly dehumanizing. Oh my gosh. I know. It really is. So that's what they're talking about here. They've also, anytime respondents were unable to provide certified copies. And this is really what the cases are about, because we're not doing trial court when we're going up on habeas. We're not doing like a huge dog and pony show because you're working with a judge there, but the judge is going to be looking at the case file and is going to be taking a look at what's going on. There is sometimes testimony that can be taken during habeas corpus situations, but it doesn't have to be necessarily. So their habeas cases are kind of their own animal here. So certified copy of petitioner's full immigration records where expressly required by court order. So they're not giving all of the paperwork to petitioner here. And that's, yeah, Wolf Girl, I'm telling you, the lawsuits, yikes, this is going to be, because this is written by the government about all the mistakes they've made. So this is freaking amazing. Miscellaneous noncompliance and other noncompliance not susceptible to categorization. So they're like, here's the stuff that we can categorize, but then there's a bunch of stuff we can't. Yikes. So that's no good here. Our office did not consider, that's the right one, did not consider the following circumstances to be violations of a court order for the purposes of this declaration. So let's take a look at that. And they're saying only in this declaration. Maybe once we get to court, it's going to be different. But here, with my declaration here, we're not taking that into consideration. All right, here we go. Missed status update deadlines. Oh my gosh. Everybody, when you're working federal cases, and they have special bits and bobs to them, like you gotta file the bits and bobs. You don't get to say, oh, I just didn't want to do it. It's like everybody else can do it. Why can't you do it? So anytime the U.S. Attorney's Office filed a letter status update or any other filing that is not a pleading after a deadline set by a court order. So then this is one thing that drives me crazy. Like, I know letters are helpful because you can just zip them out to the judge, put it on the docket. And so you're not messing around with the full pleading that requires certain things. So letters really quick, like, dear judge, I'm sorry, I'm going to need 2 more days because my kid's graduating from blah, 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 blah. Right? Those letters that come in, those are not pleadings. They're letters. And so a full pleading is always best. Always best unless the court asks for it. And I've seen courts do that too. Like say, hey, just zip me a letter on it as opposed to a full pleading. All right. Lack of notice of petition. Anytime the court issued an order that respondents did not comply. Oh no, I got to puzzle everybody. Oh, I'm so worried. Oh, it's just blue and brown. Ah. All right, hold on, everyone. Oh, I'm so nervous. No. Oh my gosh, we got it. Oh, all right. I'm gonna need a little bit of hot cocoa after that because that always scares me every time. I hate it so much. All right, back to it. So I promise there's charts, everyone. I promise. All right. Anytime the court issued an order that respondents did not comply with because the office was not added to the docket by the clerk's office in accordance with a memorandum of understanding, or our office was added to the docket after the order was issued and the office did not have actual and timely notice of the petition. So here's another point where they're kind of whining and they're saying, we didn't get our stuff on time, and so don't blame us, blame other people. Oh my gosh, I agree, Carol. I agree. Will there be stick figures? That's always a possibility, VC. You know that. You know that. We're going to do that soon. I tried to bring the other one. Okay, squirrel. Back to it. Here we go. Although our office did not consider the above 2 circumstances responsive to the February 5th order, the office nonetheless searched for any such instances having occurred between December 5th and February 12th. So they're saying like, oh, we even did extra work. Like, I doubt it. And provide that information in this declaration in the interest of transparency and the court's consideration. And then we've got our search methodology. Here we go. Let's bump this up a little bit. So how they went about the things here. Our office placed broad parameters on our search for any of the above violations within the relevant time frame. So it looks like they just wrote out what they're looking for and they're like, okay, how many do we have? As opposed to looking through, seeing the violations and then writing it down. So they're going backwards on it. The February 5th order directed the office to enumerate violations occurring from December 5th to present, which we construe as February 12th for the sake of completing this declaration by February 13th. Hello, Ray. Hi, welcome in. 11, to identify violations that occurred within the time frame assigned, the U.S. Attorney's Office reviewed their respective dockets of every immigration habeas matter logged into our internal tracking system from October 5th, which is 60 days prior to December 5th, starting point ordered by the court. I don't know. It seems like this is the time. Oh, right. This is where we start to see like, we're sorry, but not really, because it's your fault. They do that a lot. By reviewing cases filed up to 60 days prior to the start of the time frame in the February 5th order, our office sought to capture with reasonable certainty all immigration habeas matters filed prior to December 5th but with a court order entered within the relevant period required by the court. This methodology was based on our experience handling hundreds of habeas petitions in recent months. Yet, everyone, they complain about how many. And we'll see that coming up here in a minute. Oh no. Oh, did she go back up, Ray? Did she? Oh my gosh. Did she go back? I hope she was able to appeal and get back up again. Yeah, that's, oh my goodness, such a bummer. Right. All right, so the methodology here was based on the experience handling hundreds. Okay, I'm glad to hear it. In recent months, and our understanding that courts in this district have resolved most habeas matters within 60 days. In addition to the AUSAs reviewing the dockets, this is the assistant ones, I think that's interesting. Reviewing the dockets in all cases filed from October 5th to February 12th, our office also reviewed our internal case files for each case to ensure it has reasonably identified and disclosed instances of noncompliance with a court order, even if not reported to the court by either party, because the issue was moot or not subject to dispute between parties. So my next piece here is if any of you have been with me when we went through all of those Mr. Orange cases, oh my gosh, some of the motions and pleadings were like 2 or 3 pages of rubbish, and then they included like 200-300 pages of documents directly from the case in court. Now, public access is fine, but they put it in to bulk up their pleadings. So they're like, here we go, we need you to do this. And then like just a couple pages, that's not enough. So they would add all these other things. And it was the first time I'd really seen people do that, because I'm like, you're supposed to keep it pretty easy here on the judges. And also anytime that stuff's got to be printed out, you're printing out like 300 pages. So that's like one of their techniques that they use here. And I'm wondering if they're going to start using it in the DOJ now. Right, exactly. Oh my gosh, right? Like I didn't even know we could cite Twitter. I would have been citing those tweets if I could have. All right. So we got to keep that in mind. When we're coming across some of these big filings, people get really worried about it. Or the people filing them are like, oh, I worked so hard. No, that may not necessarily be the truth. Number 15, because immigration habeas dockets are subject to limitations on remote access to electronic files pursuant to Federal Rule of Civil Procedure 5.2. So now we're complaining. Each assistant U.S. attorney assigned to any case performed the search, him or herself, with the exception of the civil chief, who appeared in only one case himself, which did not have a violation, and in other cases where the assigned assistant U.S. attorney conducted the search to identify any violations. All right, so these attorneys, just as quick insight, these attorneys are dealing with hundreds of cases. It's not just habeas, it's also the entire federal criminal justice system. So these attorneys, they're already like, Aaron, I see you. Oh my gosh, you cracked me up. I'm sorry, squirrel. So they're asking these attorneys to start going through basically the equivalent of boxes. I mean, of course, it's all on the computer, but they're having to go through and find anything in there that could potentially fit in this category on top of all of the other work they're doing. Why? Because there's no one left. There's just not anybody left. Well, hello, fish taco guy. Oh my gosh, I want tacos now. Give me all the tacos, please. I'll take that. All right, just a couple more sentences here, everyone, that we can really start looking into these charts that they put together. So 16 in total, 24 assistant USAs and additional support staff revived approximately 547 immigration habeas matters for possible violations of court orders. That's too many. Like, who gets away with this crap? Oh my gosh, tacos. Yes, can I have more tacos, please? Oh my gosh, the timing, you guys. That's just brilliant. The timing. Oh my gosh. All right. All right, you both won the internet tonight. All right. Gotta get past the squirrels. So 547 immigration habeas matters for possible violations of court orders occurring between the relevant period, December 5th through February 12th. Tacos for the win, always, right? Always. All right, everyone, let's dive into these charts, which is really where I was heading. Now, here's the first one. So number 18, our office identified 6 missed answer deadlines out of 547 matters. So this is the reason why they wanted to get the number of cases, right? Because that's really huge. That's a really big number. And when they're saying, oh, we only missed 6 deadlines out of 547, that looks pretty good, right? No, as attorneys, we cannot miss one deadline. We can lose our license for missing one deadline. And they're like, well, we've only got 6. That's huge. That's huge, right? So let's take a look at that. Beef or chicken? I want all of those. And put the french fries in there. I know, I've just triggered people. That's fine. Here we go. Here's the docket number here, 1 through 6. So they're showing these are the cases, the 6 cases where we missed answering it. So again, with the chart that I made, which I just put somewhere else. Hold on, let me get the chart back. We need the chart. Here we go. And only the highest qualities for the lives, everyone. Here, look at my scratched out notes. Oh my gosh. All right. So the petition and then the answer, right? I mean, let's not even pay attention to this kind of rubbish. But the petition's filed and then they have a certain number of days to file the answer. So they missed filing the actual answer to these petitions. That's huge. I mean, 6 times, that's huge. I mean, in normal people world. So here's the first one. With consent from adversary, like, it's kind of rude. Respondents filed a response to bond challenges at 10:23 a.m. instead of at 9 a.m. Now they're minimizing. If you've got a due time of 9 a.m., get it done on time. Dang. This is like normal, regular lawland business. Next, missed answer deadline here. Case assigned to AUSA after the deadline, and AUSA filed answer promptly thereafter. Now, I get it and I appreciate how we're able to go through this, but I would have liked to see some dates. So if this was like an assignment, as writing, research and writing, I would have said, let's put some dates in here. That'd make me feel a lot better giving this to the judge. All right, next, missed deadline. Respondents missed answer deadline by 48 hours. This seems like they're kind of like complaining here. Like, oh, we were so close. We only missed it by 48 hours. What the age, man? What the age? Respondents filed response to a bond challenge several days late. I see several hasn't been counted out, but 48 hours has been. I think that's interesting. Missed initial answer deadline. Petitioner consented to extension of time to answer, which was ordered by the court. All of their deadlines were met. So again, you missed the deadline. You missed the deadline. If they want to come in and say, all right, well, go ahead, just do whatever you need to do, because they want to move on with their case. They need to get their case rolling here. And they're like, no, everybody thought it was fine. I'm like, all right. In college, a lot. Oh my gosh, that's so true. That's incredibly true. Here we go. Missed answer deadline. Last one. Filed answer 3 hours late with request to accept nunc pro tunc arose from technology issued with ECF. Oh my gosh. So, oh my gosh, tech is never supposed to be your excuse for why you've missed a deadline. You come in with a tech question, and we're all going to stand there and look at you. Like, we've all been there. But if your whole place, if your whole region isn't shut down, you're going to have problems. And again, 3 hours late, that's way, way too far. Right. Our computers didn't work. My dog ate my homework. Yeah, no, that's not acceptable. So they've missed some things that are pretty major, could be found in contempt, even for that. I know, even cringe to say that. I know. Ugh. All right, so here we go. We finished that one out. So 6 missed answer deadlines. Again, if you miss a deadline in the real world, you could have some significant problems. Right. Well, exactly, VC. Exactly. Be creative. You don't, but they're not. They're not. I shudder to think of who is actually left at the DOJ. Some people are like, oh, all the good ones don't leave because then it'll be a mess. To which I answer, if you're one of the good ones, you need to just walk away, because how else is the American people gonna know how important our DOJ is, right? So we're going through a tough period here. Next, office identified 12 missed bond hearing deadlines. Again, that bond hearing is that moment to, sorry. What is non-pro-tonque? All right, well, let me just double check. Here we go. I'm going to look it up here. Hold on. After the major question doctrine the other day, I'm like, I better look up my stuff here. Right, non-pro, okay, there, no, that's, okay, right. People are like, oh, we already Googled it, see, your book is so slow. It's true. Yep, you're right. Non-pro. Here we go. Sorry, everybody. All right. Let's see here. I thought it was supposed to be, just a minute here. Let me make sure. Nunc pro. Yeah, nunc. N-U-N. Thanks, everybody. I can't even use a dictionary. My spelling's so bad. Oh my gosh. All right. Nunc pro. Should be here. Nope, not nuptial, right? Nunc pro tongue. Oh my gosh, we found it. That was a journey we all went on together. Thank you, everybody. Appreciate that. Oh my gosh. All right, here we go. So nunc pro tonque, it's Latin for now for then, having retroactive legal effect through a court's inherent power. The court entered a nunc pro tonque order to correct a clerical error in the record. Oh, all right. So we're talking retroactively. So that's going to say, let me make sure I get the right one here. Here we go. Filed answer 3 hours late with request to accept nunc pro tonque. So they're saying we didn't have everything filed at the right time, but we're asking for it to be allowed in. All right. Rose from technology issues. Again, let me get into, right, judicial whiteout. I think that's a good one. I hate having to search words. Oh, I know. Right. Tech has spoiled everyone, or has revealed their weakest link. Like if I had to spell something serious in order for my whole family to not be unalived, I would be like, just unalive me right now. Because I'm not going to be able to do that. Oh my goodness. Yes. All right. So we're looking retroactively here. And sometimes that can happen where you call the judge up and you're like, dude, and he's like, well, which one, let's put an order together. It's like, fine, whatever. All right, the office identified 12 missed bond hearings. Now, this is huge because the peoples are in the detention, and if they're entitled to bond, they should be allowed to bond out. I think the best example of this is going to be on the, I just was going to say his name, but now I have forgot. It just flew out of my mind. Hold on. I was saying his name wrong. Oh my goodness. Hold on, it's going to come to me here in a minute. Abrego Garcia. Woo! My goodness. Almost lost faith in myself. According to his case, he had two, right? So he had the government case and then, the big one, and then he had the Tennessee case. All right. So when we're in a situation and where this kind of crap's going on, the judge specifically said I can't remember now, was it the government or the Tennessee government case? Anyway, they just basically said, this is how much bond would be if we needed to do bond, but he meets all of the bond requirements. And so the court's like, you got to let him go. And so that whole time they were like rushing around to see if they could figure out a way to keep him in detention. And there wasn't. Like, you got to let him go. You got a court order there. So there was a bit of an issue for those of you who were following that case on the specific issue of bond and how much it should be and who gets allowed out of detention. Oh, thanks, Maui. Oh, thanks so much. Tennessee was the one. Okay. Educate. Absolutely. And Kenneth, don't ever forget, I'm over on the tube. And that's nice because then you can fast forward through all the squirrel moments. Oh, thanks, Scott. Oh, my gosh. Thank you so much. I appreciate you. Next, here's the bond hearing, right? So occurred 1 day late. Doesn't matter if it's 1 hour. Well, if it's 1 hour, the judge will probably be coming out and looking at you because you're in the courthouse at the same time. But 1 day late, here's another one. That's another 1 day late. You can't be late to bond hearings. What is that? That's awful. Bond hearings, out of everything that you're doing, be able to decide what's going to happen and stop taking away their freedom. Freedom's the most important thing. You don't go in and work on the situation so they're in jail or detained longer. Sorry, everybody. It just gets me so upset when you detain people illegally. Don't let them out because of your own mistake. I have no reason to keep... Well, exactly. They moved him around quite a bit. Yeah. And he, by the end of it, my understanding is he's like, hey, I'll go to Costa Rica. I'll go to Costa Rica right now. You don't want me here in this country? Fine. I'll go to Costa Rica. And they're still like, man, I don't know about that. Next bond hearing here. Yeah. Yes, indeed. 2 petitioners in the same case. Immigration court timely scheduled one, but not the other. Bond hearing conducted 1 day late for second petitioner. Okay, could be, or I could not be. We don't really know, but that's what he's saying. And the parking lot to be on time. Oh yeah. Well, yes, and You don't want to be late to court. You don't want to miss court because especially if you are in front of the same judge a lot, because that judge will be like, if you're not here 30 minutes early, you're going to be going to jail. And then last one, bond hearing. Well, that's only 4. Occurred by 1 day late. All right. So again, it seems like they're trying to just say, well, it wasn't that bad. When the question is, did you violate the order? That's yes or no. That's not like, well, we kind of did. No, yes or no, you violated. Here we go. Next one, the bond hearing scheduled for next business day after the deadline. Yeah, maybe. Maybe bond hearing occurred 1 day late. Why are we only at 1 day here? Bond hearing ordered, but this thing was closed for extended holiday period. So, deadline missed. All right. Well, holidays, gotta have that. Bond hearing ordered, but EOIR was closed again for extended holiday periods. What? All right. Well, if it's, holidays, you just gotta leave them in there for a while before you help them out. That drives me crazy. We have another bond hearing here, 2 days late. 2 petitioners, one received a bond hearing 7 days late. 7 days, 7 extra days. They're in detention here. Yeah, exactly. It's everybody else's fault. It's not mine. Bond hearing late because timely scheduled bond hearing was canceled due to EOIR closure for bad weather. I'm assuming, and hold on, I could be wrong, everybody, but I'm assuming that we're talking about the courts when they're saying EOIR. I'm assuming that's the courts. Let me double check though. Again, I just want to make sure I'm right on that one. Okay, EOIR. Oh my goodness. Yeah, my legs aren't working. Okay, Executive Office for Immigration Review. Okay, now I don't feel so bad about not knowing that. So the Executive Office of Immigration Review. So the immigration courts were out. Yes, thank you. S'mores? Oh my gosh. Yes, please. S'mores. Right, thank you, everybody. Appreciate that. But yeah, so I guess their office was closed to weather too. Like that happens, sometimes that does happen. You work around it. But I don't think because your office here, the executive office was closed, is what, oh my goodness gracious. Oh my gosh, oh Dolphin. Oh, that was so sweet. Oh my gosh, that's just beautiful. I appreciate that so much. A little pick me up here. Yikes. Oh, thank you. Right. If they're closed, why would the judge care? Well, right, exactly. I don't think the judge is really talking about scheduled closings or emergencies. That was really cool. Yeah, absolutely. All right, next, 17 post-injunction transfers out of 547. Again, they're trying to say we've only got this many. Oh, of course, we do love that. They're just amazing. I think all of our ocean stuff's amazing, but I'm not going in the ocean. I said what I said. We'll leave it there. Next, post-injunction. All right, so here's the transfer. So we're going to hopefully get some idea of where they're shipping everybody out to. ICE violated no transfer order, but returned petitioner to New Jersey. So we don't know where they went to start. Southern District of New York issued no transfer injunction on November 6th. ICE transferred petitioner on November 13th and returned petitioner to New Jersey. Again, we don't know where they got taken to. We just don't know. Okay, transfer petitioner at the same time injunction notice issued at 9:44 a.m. This is when they're starting to get, come on, guys. ICE returned petitioner to New Jersey. All right. Violated no transfer order, but returned that person back to New Jersey. Cubes violated another no transfer order. So they're not telling us where they're taking them. Is that interesting? Here's another one. No transfer order. Violated another one here. Yeah, they're not giving us deets on that. I think that's very interesting. Right. That they're not saying, yeah, well, we had to get them back from Djibouti. I can't remember, is that right? Probably not saying that name right. Forgive me. An African country. Let's just put it like that. The only African country that I know anything about is Tanzania, if that explains where I'm at. Here we go. Another one. 12:41 p.m. Transferred at 2 p.m. Ordered. All right, so they're late by a couple hours. Again, this is courts. You don't Djibouti. Oh, thank goodness. I was like, did I get the Djibouti wrong? But come on, this is court. You can't be like 2 hours late to court. Like what? Order January 12th at 11:42 a.m. Transferred at 3:30 p.m. Nope. I mean, yeah. Get yourself sorted out here, people. Issued injunction here, 1234, Cube's transfer petitioner at 219 and returned to New Jersey. All right, we're still running your booty. Oh my goodness. All right, court issued injunction January 26th. They transferred petitioner and facilitated petitioner's return. So I feel like they're just driving these people around, right? I mean, I'm not sure that we're on planes unless we go to another country, but is that what we're doing here? We're just driving them around? Because that's crazy. Why do you keep, oh, really? Yeah, it's really cool. It's really cool. I've never been there, but I'm very interested in the deets. Right? I know there's a lot. Many of them have been found, luckily, but yeah, that's crazy. That's crazy. We're just driving people around. We're not telling anybody where we're going. When we defy a court order, we'll say sorry when we get back. Ooh, well, time change. Oh, interesting. Although I don't know. I mean, are they using what do we call it? The military thing? I don't know, everybody. My mind just went blah. Tax dollars at work. True story. Here we go. All right, we're almost here to the end. Okay. This makes me really upset. So let me just get another little drink of the cocoa here. Have not been found. Oh my gosh. Oh, it's such a huge issue. And people are tracking them down every day. Let me just put that out there. The resources in the legal community and various other communities, and even some of our churches are trying to run after the people who've not been identified yet. So there are people doing things, but it's just awful. All right, transferred 40 minutes after the non-transfer order. Again, does 40 minutes matter? Cubes violated no transfer order. Okay, here we go. So took the petitioner to Brooklyn and returned the same day. So, all right, we at least have one here. Next, violated no rights. Transfer order. Cube's process of returning. So this one's not even been all the way back yet. I mean, probably is by now, but they fired 8 agents. Oh my gosh. I'm not surprised. And geez, even just working in nothing as elaborate as a U.S. attorney's office, but just working in the prosecutor offices I've worked in, like, my goodness gracious. I can't even imagine the point that they must be at. I mean, when it comes to everything it takes to get a case up and running and all of the stuff that they've got to track down even before like a regular case was going, it's like it's a lot. It's a lot. I can see why people are losing their minds, but if you're going to lose your mind, perhaps you should resign. And I don't say that lightly. All right, here we go. All right, return. So here's number 21. Upon review of each post-injunctive transfer, respondents have indicated that the transfer occurred inadvertently. I just can't. Seriously? The transfer occurred inadvertently due to logistical delays in communicating the court order to the relevant custodians or to administrative oversight of the court. Oh my God. In each case, respondents agreed to return the petition to the District of New Jersey to regain compliance with the order. This office has obtained no indication that respondents intentionally engaged in any above post injunction transfers. Are you freaking kidding me? This is not good. Oh, exactly, Doughboy. No. Like, Oh my God, what is happening? This is crazy. No, there's no inadvertently with the people. All right? You know, inadvertently, these are people. These are human beings. I mean, what the H? That's, all right. Inadvertently, quite frankly, I think I would probably sue for, well, we could do kidnapping if you go that direction. So kidnapping, let's see for that, right? All right, that's awful. Yeah, it's just awful. It's awful. Let's read it one more time, and then we'll move on. Here it is. Respondents have indicated that the transferred occurred inadvertently due to logistical delays in communicating the court order. This is what absolutely blew the judge in DC's mind when they were saying, well, we didn't have the order. We don't know who had the order. I'm not sure. Who had it? We don't know. And the judge's like, are you freaking kidding me? We're not dealing with that nonsense. Be professional. All right. In each case, respondents agreed to return the petition here to New Jersey to regain compliance. And that's what we do with contempt. A lot of times people forget that, and the judge will ask, how are you going to cure it? How are you going to cure the problem that you created? Next, the office identifies one post-injunction removal out of 547 cases. Again, each time that number is supposed to somehow help that there was a problem. ICE, aware of injunction but erroneously removed petitioner to Peru. We're going to Peru, everybody. Oh my goodness gracious. Oh my goodness. Oh my gosh. Parties consensually agreed to voluntary dismissal of petition without any remedy imposed by the court. You can't just send people to Peru. My goodness gracious. Oh my gosh, that's going to give me nightmares. I'm going to have nightmares. All right. So basically, anybody that gets picked up by the people who are doing all of this crap, if you're getting tangled up in this stuff, don't be sending them to another foreign country. You don't accidentally get booked to Peru. You don't. That's why there were some questions before on if they were, some people are saying they were using military air things. Oh my gosh, I'm sorry, everybody. There's multiple things flying in the air. Some people are saying they use that. Not Peru. Oh, really? It was Uganda. Was it Uganda? How do I get deported to Costa Rica? Asking for a friend. Same. I've already asked. They're not giving that information out. They won't tell us. All right. Well, another country that is not where they're from. I know, VC, it's a lot. Upon review of this post-injunction removal, respondents indicated that the removal occurred due to an inadvertent administrative oversight by the local cube custodian. Respondents cooperated with petitioners' counsel to facilitate petitioners' return to the United States. Petitioner decided to remain in Peru. I don't blame you, man. I don't blame you. You come back to the U.S., next thing you know, where are you at? Indonesia. Who freaking knows anymore? Oh my gosh, it's so awful. We should be more angry. Yeah, we also have to pace ourselves. So we gotta pace the anger, all right? Okay, petitioner decided to remain in Peru instead of return to the United States. This office has obtained no indication that respondents intentionally removed the petitioner despite the injunction. So the court's saying, you guys just screwed up. We don't think you're doing it in bad faith. Is what the people writing this is saying. So this is the government writing this. All right, office identified 3 late releases from custody. Okay, so let's take a look. Cubes released 30 hours after release deadline, not raised to court. So 30 hours after release, again, that's still 30 hours. January 15th for same day release, released on January 16th at 8:47 in the morning. That's still another night in detention. Next, released 9 minutes after deadline. Come on, really? Come on. And even if it is 9 minutes, 9 minutes is 9 minutes. But this is where we're starting to get petty here, I think. This, I met your mother. Oh my goodness gracious. That's funny. All right. Office identified 3 instances in which the cubes imposed alternatives to detention. That's the ATD acronym we've been talking about. Post-release without a court order authorizing ATD out of 547. Again, it's like, okay, whatever. So, post-release, no order prohibiting, but court ruled ATD unlawful. Post-release, ADT imposed prior to December 5th. Fitted with an ankle monitor in violation of court limitations on release conditions. Court also ordered immediate release after delay in processing a petitioner's bond. Oh my gosh. So, yeah, that's what it says, is that they're in Peru. But at this point, I think any country is a possibility here. All right, hold on just a minute. Where did we go? Yeah, so we've got the ankle monitor here. And then they put the petitioner on a reporting schedule in violation of court limitations. So they said you need to report in a certain amount of times. And the court said, no, they did not have to. So that was a violation of the court order. Yeah, I'm like, if I got to get on a plane and go to Peru and look around and be like, I can make that happen. I can make it happen. Here we go, next one. 10 instances in which a judge deemed respondents' evidentiary production incomplete. Now, this is part of that discovery process. We've talked about this before, where you've got to give information over to the other side. Because if you're in a lawsuit, there's 2 sides. Well, you're supposed to give information to each other. And if you withhold information, evidence, any of that kind of stuff, then you are in the wrong. So what they're saying here is like, man, we didn't give everything. And so the court's like, you were supposed to. So that's a violation. Noam's plane, I don't know. I hear the FBI plane could be up for anybody if they wanted to. Here we go, incomplete production. Respondents did not produce witness or declaration required by the court. They didn't talk about witness. They're like, what's your witness sheet look like? Well, we don't have one. No, that's not okay. Did not produce complete certified record of petitioner's immigration. Oh my gosh. Wow. If you don't have that complete record, you're going to struggle if you need to appeal. Respondents did not produce complete certified record of the immigration. Again, that's a key piece of evidence. Respondents did not produce complete certified record. Again, did not produce complete certified record of petitioner's immigration. I think it's probably because they don't have one. They're just kind of throwing stuff together here. Right. So, didn't produce, again, the complete certificate record. Like, how do you know they need to go if you don't have a record of it? Let's go sideways here. Right. All right, couple more. Didn't produce complete certified record again. Did not complete certified record again. Did not produce. This is a big deal, actually. Did not produce. How many of these they have? They've got like 6 of these. That's like way out of line for, being a lawyer. So, well, whatever. That's, right. All right. here we go, 27. In many of these matters, respondents were unable to comply with the court's order directing respondents inter alia to include a certification attesting to the completeness of all immigration documents produced within the response deadline because many immigration records were in the custody of other departments. Really? They're saying they couldn't get them because they were with other departments. What? Like if another department has it, you can be like, dudes, can we have that? I mean, what's the deal here? That's I don't know. I mean, are they trying to hint that there's bad stuff going on with this particular person? Because who cares about that? Yes. Habitually incompetent. Right. That's well said. Exactly. This office has obtained no indication that respondents intentionally did not comply with the court's order. Again, the government is writing this. Next, the office identified 4 miscellaneous instances here of possible non-compliance. So they're saying, we don't know if we complied or not. We don't know. So that's this last piece. Voluntary departure. Respondents removed petitioner from the United States because petitioner requested voluntary departure. Injunction against removal was in place at the time of voluntary departure. These voluntary departures, that word voluntary is not being used properly. So anytime you've got voluntary put in here, it's not like, well, they said yes. No, there's a strict legal definition when it comes to is something voluntarily done or not. Although no transfer prohibition or specific deadline to release petitioner filed challenge to delays, posting bond and post-bond order transfer. I mean, they're dinking around instead of doing what they need to do. I mean, goodness gracious. Challenge still under review by the court. All right, so we don't know yet. Although no deadline to release the petitioner's bond did not post for several days. So they're saying, well, who cares? We didn't have a deadline, so whatever. Although no deadline again to release petitioner's bond did not post for several days again. So that's kind of an internal issue again. Next, number 29. With respect to circumstances that the office did not consider to be respondent's violation of a judicial order, the office provides information regarding those circumstances in the interest of transparency. Yeah, nothing but transparency with this administration. And 30, the office identified 16 missed status update deadlines. That's a lot. That's actually a lot, unless they're combining it from all different cases. The office identified 3 instances where respondents did not comply with the deadline because the office was added late to the docket and lacked actual notice of a deadline. All right, and then this dude here wrote this. All right, so what are our thoughts here, everyone? What are our thoughts? And in a non-swearing way, in a way that doesn't involve swearing. Attorneys not losing their religion on these. Oh my gosh. Well, we're having to really hold each other up in this moment, quite frankly. A lot of us are. And especially for those who have worked. Listen, if you've worked in the legal system, thank you. I thank you. But if you've worked in the criminal system at all, or civil contempt, or any of those, this is just like mind-blowing. These are administrative laws that they're dealing with, right? So the administrative act, but we've also got elements of the 4th, the 5th, and the 6th Amendment, right? So if you're detaining people, and the 8th, in my humble opinion, that's going to take a little time though, because we don't have final decisions. But that's a lot. We've got a lot of constitutional questions going on. I mean, can you imagine just getting picked up? You're like, oh, okay, well, you don't have your paperwork, so let's smush you into this van with everybody else. And then, like, okay, 5 people line up, we're going to Peru. Like, how is that all right? How is that not the trafficking? Crockett would have made a good U.S. She still could, Wolf Girl. She's still got a lot in there when it comes to intelligence and time because she's so young. I was told I can't say anything without swearing, not to say anything at all. Well, yeah. Yeah, I have a swearing issue that I work on every day. And if you think about it, it's because swear words, your throat goes in a certain direction, right? And so your whole mouth is making the sound when you're swearing, and they're really sharp letters. So it's almost like you're relieving some of the upsettedness from your face because of how those muscles work. I don't science, but somebody told me that. President on down the atmospheres now. Oh, I know. Exactly. Point fingers. And if there's enough people to point fingers at, then they'll just give up because they're like, oh, this is too hard. But see, you push a judge so hard that they're pissed off at you. I mean, it's like a crocodile. They're not going to release the jaws. That's going to be in there for, they're going to be like, you're coming back and we're taking care of business. Well, I mean, yeah. So again, we got to follow the rules. I'm not saying, and this is one thing I think a lot of people forget. I'm not saying we can't have people deported. That's stupid. Of course we can't. But I would say, can you frickin' follow the law? Like, if you can't follow the law in this area, I'm not going to back you up. But if you were following the law, I'd be like, man, I don't care for it, but you're following the law. And there would be that situation. But they're not. They're not. And they're not, and it seems like they almost just don't care. I mean, if you're losing somebody that you put in Peru, like, come on. Are you kidding me? Exactly. That's what I'm saying, Paul Walker. That's what I'm saying. We're counting on the judges to keep it all together. Well, the thing about the judges is that they've got a whole, posse behind them, right? It's not just the judge. It's the clerks. It's the other people, the associate judges. It's everybody. So the support crew plus the judge. And that makes a difference. At the DOJ, it looks like they don't even have enough attorneys to not have attorneys having to do go through all this paperwork themselves to find what they're looking for. That should not be happening. That should be, paralegal, legal secretary, which I know no one's called legal secretary anymore, and it is quite insulting. But so let's just say paralegals and all of that, they're all necessary to complete a case, in my opinion. Can we impeach Supreme Court judges? Yes, and AOC tried. She did try with Alito, and Thomas actually had articles of impeachment drafted. But of course, with the state of our Congress, that didn't really go anywhere. I don't think it got out of committee. Yeah, it's tough. It's tough. Well, and Cass, as you know, that road is confusing now because before all this crap went down on the second impeachment for the orange fella, people were like, all right, this is this, and then criminal is criminal, and we're going to just do that. And then that turtle fella was like, all this needs to be handled in the courts, right? So then we took him to the courts, and the turtle fella was like, I changed my mind. This is just impeachment. But they're like, we're not going to impeach because this should be in court. In court, they're like, no, this should be impeached. So that back and forth with the turtle fella, ooh, it upsets me. It upsets me. Oh my gosh. Right. Everybody, you all know what I mean when I say the turtle fella, right? I'm not good with names. He's not coming back. Right. Right. Well, at least it was the sweater guy. I still can't remember that guy's name. Oh, right. Yeah, exactly. Righteous giggles, of course. Right? Isn't he? Oh, no, that can't be right. That can't be right. I know he's not coming back, but I'm not sure if he's down that road yet. I don't know, June Marie. Good question. Good question. Well, I tell you, it was him. We were 6 votes away from super majority that would have convicted. 6. That's it. So, I mean, it was close. It was very close. No, Carol, no. Nope. Just keep those to yourself. If you can't help yourself, write them on a piece of paper and then just put it in the corner. We don't want that. Do so much. Well, right. Oh, my goodness gracious. Yeah, it's tough. Oh no. Well, Jenny, no worries. I am trying to, for my most recent lives, get them up on the tube quicker, the best that I can. I hate it. Is Mitch going to the 7 circle? I don't know. I'm not sure how many circles there are regarding that. Oh my gosh. Yeah, we're definitely in a history making era, right? That's kind of how I look at it. Timeline issues with these. Well, yeah, timeline's incredibly important. And you're seeing here just with this one case, right? In this one case, we're seeing all of these violations that they admit they're doing. They are wrote this themselves. So 666 case. Somebody's maybe, oh my gosh, OVC. What? All right, well, we'll see. That's going to be very interesting, I wonder. So I will come back again, though, everyone, when I've got a bit more time and I've read through the DVD case better than what I have here. So I need a little time for that. And I also have, again, as promised, 6 months later, I'm working on getting a live together for the Loper Bright case. That one is like a Wisco special. So we've got the Chevron case, right, that was overturned by the Loper Bright case. So that is also on my docket. So hopefully we'll be able to get through that. Oh, I know. Ooh, gross. Don't sit. No. Gross. We don't talk about that. We don't use the G and the B words together. Weird. Right. So we'll see. But with that, my friends, thanks for coming and hanging out with me. I appreciate you all so much. I truly do. And the moderators who are working so hard these days, extra hard these days, I appreciate you all. So I'll be back again as soon as possible, especially with my sparkly nails. Can't miss that. But take care, everyone. Have a great rest of your night. I'll see you all again very soon.